If I asked you to define a lease, you'd probably tell me it's a contract where you pay rent to use someone else's property. And you'd be right for, a quick definition. But the moment you sign a lease for an apartment, a car, or even a piece of industrial machinery, you are not just signing a fancy receipt. You are accepting a legal instrument, a hybrid contract that, in the case of real estate, literally conveys a form of property ownership to you, the temporary user.
That's the critical point we miss in the rush to get the keys. We tend to see the lease as a simple transactional agreement, purely governed by the rules of commerce. But in the eyes of the law, especially when dealing with land, a lease is far more potent than your average contract. It grants rights that predate modern consumer protection by centuries.
Okay, let's unpack this. At its core, we have a fundamental contractual arrangement built around two roles. We have the lessor, that's the owner who grants the use of their asset, and we have the lessee, that's the user who compensates the owner for that use, typically through periodic payments.
And the asset itself is incredibly versatile. It can be a building, a vehicle, a specific intellectual property right, or a specialized manufacturing robot. But here is where it gets really interesting, particularly regarding real estate in the United States. A lease for land or property is considered a hybrid sort of contract.
Hybrid how? Because you mentioned that element of property rights. That sounds like something you deal with when buying a house, not renting one.
Precisely. It's a hybrid because it is governed by contract law, the rules about payment, termination, and breach. But it is also, at its foundation, a conveyance of possessory rights. It carries qualities of a deed. When the owner grants you a lease, they are effectively handing over the right of exclusive possession for a limited period.
So if I sign a lease and the landlord decides they need to store their old furniture in my closet, or decides to repaint the living room while I'm at work without notice, they are not just breaking a contract, they are potentially violating my legal possession of that space.
That's the perfect illustration. You are legally holding that space for a set term. Your right to possession is exclusive, even against the lessor, unless the lessor has a specific legal reason to enter, like an emergency or prearranged access. Any unauthorized interference with your right to quiet enjoyment while you are in lawful possession is a violation of the conveyance.
So our mission today is to dig beyond the rent payment. We're going to dissect the essential legal elements that build this powerful contract, trace its historical roots, and explore the four distinct legal structures that define how we can occupy land. We'll also see how these dense rules apply to everything from complex industrial machinery to that rental car you picked up at the airport last week. Let's start with the non-negotiables. If you're drafting a lease or signing one, there are specific boxes that absolutely must be checked for it to be a legally enforceable agreement. These aren't suggestions, they are the foundational framework.
They are the bedrock. First, you need clear identification of the parties. Who is the lessor and who is the lessee? This might sound obvious, but ensuring the owner listed is the actual legal owner or agent is crucial.
Right. You don't want to be paying rent to the wrong person.
Exactly. Second, the duration is fundamental. The starting date and the precise term of the agreement must be clear. Vague terms lead to legal ambiguity.
And if we're leasing something tangible, we need to know exactly what we're leasing.
Absolutely. Third, you must specifically identify the asset being leased. For real property, this means the street address, unit number, and legal description of the premises. For a car, it requires the vehicle identification number, or VIN. For specialized equipment, it must include the serial number, make, and model. If this identification is faulty, the entire contract can be void for vagueness.
And fourth, of course, is the consideration of the payment structure.
Yes. Is it a lump sum paid up front? Or the typical periodic payments, say monthly or quarterly? This must be explicit. And fifth, which often gets buried in the fine print, are the specifics regarding the security deposit. Critically, the contract must define the terms for its return, including acceptable timelines and what damages can be legitimately deducted.
Finally, we need the exit plan, right? The end of the contract.
Correct. The lease must provide clear conditions for renewal or non-renewal of the agreement, specifying how and when notice must be given if one party wishes to continue or terminate the arrangement.
Okay, that covers the basics. But the real hazard, and where a lessee can face significant unexpected costs, lies in the protective clauses and obligations buried deeper in the text. This dictates the behavior expected of the lessee and the massive liabilities they accept.
These clauses are the lessor's attempt to mitigate the risk. For example, the lease may have strict insurance requirements for loss. For commercial property or leased vehicles, the lessee is often required to maintain comprehensive insurance, specifying certain deductible limits or even requiring the lessor to be named as an additional insured party.
We also often see restrictions on how the asset can be used.
Precisely, the restrictive use clauses. In a car lease, this might include mileage limitations, like, say, 10,000 miles per year, or a prohibition on modifying the vehicle. For commercial space, it might prohibit certain kinds of manufacturing or dictate operating hours to manage noise or environmental impact. The purpose is strictly asset protection and risk management.
Then there is the endless battle of maintenance. Who pays when the air conditioner breaks?
The lease must provide clear guidance on maintenance responsibility. Is the lessee responsible for all non-structural repairs? Is the lessor responsible for the major systems, like the roof or foundation? This has to be explicit, often defined by the type of lease, like a gross net or triple net lease, which we can touch on later.
And finally, that critical exit clause, the termination provision.
The termination clause is non-negotiable and must detail the process for early cancellation or default. It must clearly state the rights and obligations of both parties and outline specific penalties for default. A well-drafted commercial lease will include a comprehensive list of default conditions, such as failure to pay rent within 5 days, bankruptcy, or abandoning the property, and the specific remedies the lessor can pursue, which might include immediate acceleration of all future rent payments.
So we have this complex legal hybrid, often drafted entirely by the lessor's legal team, creating an inherent imbalance. This brings us to a crucial modern topic, the requirements for an agreement to be truly transparent. Just because a contract is signed doesn't mean every term is fairly presented.
This is a massive area of focus in modern consumer law, recognizing that the assumption of equal bargaining power is often fiction. We can look to the Australian Consumer Law of 2013, which provides an excellent framework for judging the requirement for a term in a standard form consumer contract to be considered transparent, and this framework is being mirrored globally.
What are those benchmark requirements?
There are 4 key criteria that should be alarm bells for any lessee if they are violated. First, the term must be expressed in reasonably plain language. If you need a corporate attorney to translate your residential lease, that term is likely not transparent. Second, it must be legible, not hidden in a microscopic font size.
Right.
Third, it needs to be presented clearly, meaning the structure is intuitive, not a single continuous run-on paragraph of legal text.
And the fourth criterion?
It must be readily available to any party affected by the term. This goes beyond the physical paper. If a key term is hidden away in a secondary digital schedule that requires multiple clicks to find, it fails the transparency test.
That makes the aha moment for our listener. Transparency isn't just about the words. It's about the entire presentation and accessibility.
Exactly. Terms that are notoriously considered not transparent include terms hidden in dense, confusing schedules or exhibits referenced but not attached to the main document. Also, the use of overly complex or technical legal language when simpler terms would suffice. Think using the term demise when they just mean lease or subordination agreement without explaining the financial implications. These flag a potential legal imbalance.
Let's pivot to the concept of payment itself. We use the terms lease and rent as synonyms, but legally, is payment always required for a conveyance of possessory rights to exist? Is rent mandatory?
It's not universally mandatory, and this takes us deep into common law history. Rent is a requirement in some U.S. jurisdictions, especially based on older common law. However, case law in places like England and Wales suggests that while rent is the hallmark of a lease, it's not strictly essential for the grant of exclusive possession to be legally recognized as a leasehold.
That feels counterintuitive. I mean, if there's no payment, why wouldn't the court just call it a gift or a permission?
Because without payment, the court will far more often construe the agreement as a license instead of a lease. The absence of rent strongly suggests there was no intention to create binding legal relations. But if there is a contract that clearly grants exclusive possession for a fixed term and no one contests it, a lease could theoretically exist even without commercial rent.
So if my parents let me live rent-free in a house they own for a fixed year, and I have the only key and exclusive possession, is that a license or a lease?
It's highly fact-dependent. But if there's no rent, it leans heavily towards a license or a tenancy at will. However, if they required you to pay a single dollar a year or perform some nominal task, that moves it closer to a lease. This is the concept of a peppercorn or nominal rent. If consideration is required by the jurisdiction, a minimal, non-commercial amount is often sufficient to satisfy that requirement. Ultimately, the presence of exclusive possession often overrides the absence of substantial rent in determining whether a contract creates a lease or a license.
That discussion about rent and possession sets the perfect stage for the history of these documents. Let's move from the specific legal anatomy of the contract back to its origins.
To understand why these agreements are structured the way they are today, we must quickly ground ourselves in history. The modern lease is a reflection of evolving societal and economic pressures.
Where did they start? Were they really for agricultural use?
Absolutely. For the bulk of their existence in common law, leases were mainly used for agricultural purposes. Landowners leased parcels to tenant farmers in return for a share of the crop or cash. This lasted for centuries. The legal focus was on the land itself, less on the structures upon it.
So the real legal transformation came with the Industrial Revolution.
It did. Everything changed dramatically in the late 18th and early 19th centuries with the massive growth of urban populations in industrialized countries. Suddenly, the need for urban landholding for residential and commercial purposes exploded. Leases quickly became the primary and most essential form of non-owner occupation in metropolitan areas.
That shift from fields to dense city blocks must have dragged property law screaming into contract law.
It created the hybrid we discussed earlier. The modern law of landlord and tenant retains the strong and often challenging influence of 19th century laissez-faire contract law. This philosophy was based on the premise that the court should not interfere with agreements freely made, because all parties were assumed to have equal bargaining power.
Which, in the context of housing scarcity, is wildly divorced from reality.
Exactly. This unequal relationship led to significant tenant hardships, especially oppressive boilerplate clauses. It took decades for this imbalance to be addressed. The eventual growth of consumerism and specific consumer protection legislation, especially concerning residential tenancies, was a direct response, attempting to moderate the harshness of the older common law that assumed parity.
That historical context grounds the single most important legal distinction you need to internalize, the difference between a lease and a license. I want to spend a moment clarifying this, because if you think you have a lease when you actually have a license, you have virtually no legal protection.
What's fascinating here is that the seminal difference hinges entirely on the concept of exclusive possession. A lease grants the lessee exclusive possession of a clearly defined space for a set period, and usually involves regular payments. The tenant, or lessee, holds a powerful legal asset called a leasehold interest, an estate in land.
If I can lock the door, exclude the world, and even tell the owner they can't come in without proper notice, that's exclusive possession. That gives me power.
It does. A license, by sharp contrast, merely entitles the licensee to use the property. They have permission, but not legal possession. A license is highly subject to termination at the will of the owner, the licenser.
So a hotel room for a week is a license. The owner can enter at any time for cleaning, or if they suspect illegal activity, and your permission to be there is entirely conditional on their rules.
That's a perfect comparison. Your ticket to a concert, your right to occupy a specific desk in a shared office space, or verbal permission to park your car in someone's driveway, all licenses. No long-term possessory rights are conveyed. If you have defined payments, set term, exclusive control over the entrance, and a degree of privacy, those factors point overwhelmingly toward a lease.
Now, once we confirm it's a valid lease and we have exclusive possession, common law classifies tenancies into 4 essential categories based on how the element of time is defined. Let's define these 4 states of time, because they dictate everything about the relationship, especially how and when the agreement ends.
The fixed-term tenancy is the easiest to grasp because it is based on absolute certainty.
Meaning definite dates.
Yes, it lasts for some fixed, definite period of time. It has a definite beginning date and a definite ending date. Despite the historical name tenancy for years, this can be for any duration. It could be tenancy for 1 week or a tenancy for 99 years. The key is that the term is fixed and known from the outset.
So the key isn't the length, it's the certainty of the duration.
Absolutely. Historically, the duration didn't even need to be strictly certain. It could be conditional upon an event, such as until the war is over. But modern statutes and common practice have largely moved away from conditional terms because they create too much legal uncertainty, favoring the fixed beginning and end date.
And what happens when the clock runs out on that fixed term?
The lease comes to an end automatically. No notice needs to be given by either party. There is no legal requirement to send a reminder letter. The lease expires by its own terms. If the tenant stays after that automatic termination, they immediately transition into our final, most dangerous category, the tenancy at sufferance.
Okay, next up, the periodic tenancy. This is probably the most common state for residential renters in the US, especially once that first fixed-term lease runs out and converts month to month.
This is the estate that exists for a term determined by the rent payment schedule, year to year, month to month, or week to week. Crucially, it automatically renews at the end of each period unless one party gives notice. It's also often the default tenancy if, say, an oral lease violates the statute of frauds. An agreement for a 5-year term made verbally, for instance, often converts into a periodic tenancy based on when the rent is paid.
If I pay rent on the first of the month, I have a month-to-month tenancy. The big differentiator here is the requirement for termination notice.
The rule is usually that either party must give notice equal to the period of the tenancy. So, if you're month to month, you need 1 month's notice. If you're year to year, it's typically 6 months' notice. Those state statutes often modify these periods.
I've heard about a specific legal trap regarding the timing of that notice. Can you walk us through that nuance?
This is the classic legal detail that causes countless disputes. In many jurisdictions, the required notice must state an effective date that is exactly on the last day of the payment period. Let's say your rent is due on the 15th of every month. If you give notice on August 1st, intending to terminate, the earliest the lease can legally end is September 14th, because the period runs from the 15th to the 14th. If you set the termination for September 1st, that notice is invalid, and you may be held liable for the entire next period, the period running from September 15th to October 14th.
Wow, so you need to know the specific dates your rent periods start and end, not just the day the check is due.
Exactly. And we must also mention the significant real-world application here, local rent control laws. In many large American cities, think California cities or parts of New York, these rent stabilization ordinances impose severe limits on the landlord's ability to terminate a residential periodic tenancy. The landlord cannot simply end the tenancy with proper notice. They must cite a specific, legally defined just cause for termination.
What are examples of those just causes they have to cite?
They are highly restrictive. They often include failure to pay rent, damage to the unit, what the law calls waste criminal activity, owner move-in, or sometimes necessary demolition or massive capital improvements that require the unit to be vacant. Without one of those causes, the tenancy can essentially run indefinitely, regardless of the notice period. This is the modern legal system actively intervening to correct the assumption of equal bargaining power.
Okay, third, tenancy at will. This sounds like a casual handshake agreement, but it can still have serious legal implications.
Conceptually, it is the loosest arrangement. It's a tenancy that either party may terminate at any time by giving reasonable notice, though many states require a minimum of 30 days' notice regardless. Crucially, unlike a periodic tenancy, it is not associated with a specific time period or a payment schedule.
So it's temporary, but potentially open-ended.
Yes. It could be short-term, such as temporary occupancy while a new formal lease is being negotiated and finalized, or it could theoretically last years, often in family arrangements. But here is the major caveat. A tenancy at will without compensation is very rare under modern common law. If you start paying rent, even an informal amount, it usually converts immediately to a periodic tenancy.
If it can be terminated by either party with just reasonable notice,
Right.
what are the legal events that automatically terminate the agreement without anyone having to give that notice?
This type of tenancy is extremely fragile and can be broken by operation of law if certain foundational conditions change. The common law recognizes several key triggers. First, if the tenant commits waste, meaning they cause significant, irreparable damage to the property. Second, if the tenant attempts to assign or transfer the tenancy to a third party. Third, if the tenant uses the property for a criminal enterprise.
And what about actions taken by the person who owns the property?
If the landlord transfers his or her interest in the property, if they sell it, or if the landlord leases the property to another person under, say, a fixed-term lease, the tenancy at will is immediately broken, often extinguishing the tenant's possessory rights. Finally, and perhaps most dramatically, the death of the tenant or the landlord automatically terminates this type of agreement.
That distinction is key. The other tenancy types often survive the death or transfer of the property, but the tenancy at will is so personal and fragile that those events break it immediately.
Exactly. And that brings us to our final estate, the tenancy at sufferance, which is the most precarious and often the most expensive for the tenant.
It sounds like legal trouble brewing.
It exists when a tenant remains in possession after the expiration of the original lease, but before the landlord has acted to either evict them or consent to a new arrangement. The tenant is technically a trespasser at this point, but this specific status allows the landlord to hold them legally liable for rent payments.
So they are an unauthorized occupant who still has to pay the bills. A highly expensive squatter living on borrowed time. What choices does the landlord have when faced with a holdover tenant?
The landlord has two, and only two options. They can treat the tenant as a trespasser and choose to evict immediately without needing further notice,
Hmm.
typically initiating summary proceedings. Or they can choose to impose a new lease on the holdover tenant, thereby treating the holdover as having accepted a renewal.
And the nature of that new imposed lease depends on the property type, right?
Correct. For a residential tenancy, the landlord typically imposes a new periodic tenancy, often month to month. For a commercial tenancy that was originally for more than a year, the new tenancy is often year to year. Otherwise, it's the same period as the period before the original lease expired.
If the landlord is imposing a new lease, can they use that opportunity to punish the tenant for holding over by drastically raising the rent, maybe doubling it?
They can. That's a common strategy. But there's a strict legal condition. The landlord can only raise the rent on the holdover tenant if the tenant was specifically told of the higher rent before the original lease expired. If the landlord failed to provide that pre-expiration notice, they must generally continue charging the old rate until the eviction is completed or a new formal lease is signed. This prevents the landlord from ambushing the tenant after the fact.
We've established how a lease begins and the four categories of time, but leases don't always end cleanly at the agreed upon date. Let's look at the specific legal mechanisms for ending a lease sooner than planned.
Beyond simply negotiating a mutual termination, there are specific legal routes. First, through pre-negotiated break or cancellation clauses, which allow one or both parties to end the lease early under defined conditions, often requiring a penalty payment or a set amount of notice.
And second, the most amicable route, the negotiated deed of surrender or yielding up.
This is a mutual agreement. The tenant approaches the landlord, usually saying, "I need to leave, I'm willing to pay X penalty or forfeit the deposit," and the landlord accepts the premises back early. This is usually documented via a formal deed to ensure the tenant is fully released from all future obligations.
What if there's a breach? That's where forfeiture comes in.
Forfeiture occurs when the tenant breaches a term, usually a substantial material breach like chronic non-payment of rent or significant damage, that allows the landlord to reclaim possession. However, the law often provides the tenant with a grace period or a right to cure the breach to fix the problem before the landlord can complete the forfeiture process and evict them.
And finally, the rare termination by operation of statute.
This is very rare in property law, but it can happen, for instance, if a specific zoning or environmental law dictates that the property can no longer be legally occupied for the purpose it was leased for. A legal requirement.
Let's introduce those two fascinating advanced property concepts that deal with the fundamental ownership structure, enfranchisement and merger. These show just how deep the rights go.
These are essential to understanding very long-term leases, especially those used in commercial real estate or British ground leases. Enfranchisement is the legal process where the tenant obtains the landlord's title to the property.
The tenant becomes the owner. Why would a tenant need this legal right? Why not just buy the property outright?
It's common when the tenant has a very long-term lease, say 99 or 999 years, and has already invested substantial capital into the structure on the land, or is only paying a ground rent. That's rent for the use of the land, not the building. Enfranchisement allows them to secure financing, develop the property without needing the landlord's future consent, and ultimately gain full control over the asset they have been maintaining.
And merger is the opposite, the death of the lease.
Merger occurs when the landlord and tenant become the same legal person. Since you cannot lease property to yourself, the possessory and ownership interests are united, the lease is automatically terminated. This is often relevant in inheritance scenarios or corporate acquisitions, where a company leases a facility and then later acquires the holding company that owns the land.
Now, let's empower the lessee again. A knowledgeable tenant can negotiate a powerful protective clause, especially in a commercial context. The right of first refusal.
The right of first refusal, or ROFR, is a highly valuable preemptive right. If the lessor decides to sell the property during the lease term, the ROFR gives the lessee the legal ability to make a purchase offer on the property before the lessor can negotiate or sell to third-party buyers.
So, if an outside buyer offers $5 million, the landlord is legally obligated to come to the tenant and say, We have an offer for $5 million. You have the right to match it, or we move forward with the third party.
Exactly. It's a key piece of leverage, particularly for tenants whose business relies entirely on that specific location, a restaurant or a major retail anchor. It protects their investment in the location, their customer base, and their infrastructure.
Let's get to the most critical practical protection for the residential tenant, the right against an intruding landlord. We established that the tenant has the right to quiet enjoyment and exclusive possession. What are the legal boundaries for the landlord who needs to enter?
Once a tenant has lawful possession, their rights are paramount. Landlords cannot enter without proper notice and authority. In many jurisdictions, this means a mandatory 24 hours written notice is required. Furthermore, the entry must occur during reasonable hours, typically 9 a.m. to 5 p.m., and the landlord must knock first and identify themselves, even with notice.
What about those rare exceptions?
Emergencies are the standard exception. If there is an imminent threat fire, burst pipe, gas leak, or necessary emergency repairs, notice requirements are typically waived, as the landlord has a duty to mitigate damage to the structure. But outside of those immediate threats, the tenant is protected.
And this leads us to the illegal practice of self-help eviction. The law creates this protected possession, so what happens if a landlord tries to bypass the legal eviction process?
This is a major area of consumer protection, and frankly, a legal horror show when it happens. In many places, including states like California, New York, and Massachusetts, self-help remedies are completely and explicitly illegal. A landlord is prohibited from using self-help, such as changing the locks, shutting off utilities like water or power, removing the tenant's personal belongings, or any form of physical coercion.
That sounds like a textbook definition of harassment. What are the actual consequences for a landlord who breaks that rule?
The penalties are severe because this constitutes a profound violation of the tenant's possessory rights. Doing so constitutes a constructive eviction or an illegal entry, exposing the landlord to massive liability. Violators can face stiff civil penalties, often including triple damages to the tenant, meaning 3 times the amount of actual financial injury plus reimbursement for the tenant's attorney's fees. It absolutely underscores that once the lease conveys those rights, the process of removing the tenant must be purely legal and cannot involve physical interference or intimidation.
We've covered the legal anatomy, but let's delve into the finances. Rent is the obvious financial obligation, but in a real estate rental agreement, there is often an entire spectrum of financial duties that pile onto the tenant, particularly in commercial leases.
A comprehensive agreement details the true cost of occupancy. Beyond the basic periodic rent and the security deposit, tenants are often required to cover significant ancillary costs. We must recognize several financial obligations, depending on the lease structure.
Walk us through the checklist of hidden costs a tenant might encounter.
Beyond the rent, tenants are commonly required to cover certain utility costs, water, gas, electricity. If the lease is structured as a net or triple net, NNN commercial lease, the tenant might also be liable for property taxes assessed against the premises, the necessary payment for property insurance on the structure, and all routine costs associated with repairs and capital replacements.
The repair issue is crucial. In a typical residential lease, the landlord pays for structural repairs, but in a commercial NNN lease, the tenant essentially carries all the risk.
Precisely. That specific lease structure is highly relevant. And in multi-unit residential or commercial properties, there's the charge known as CAM, which stands for Common Area Maintenance.
Let's unpack CAM. What exactly does that cover, and why is it separate from rent?
CAM is the tenant's proportional contribution to the costs associated with maintaining shared areas necessary for the functioning of the property. This includes things like landscaping, parking lot upkeep, lighting in hallways and lobbies, elevator maintenance contracts, snow removal, security services, and sometimes even the management company's administrative fees.
So if the lobby carpet needs replacing or the garage lights are out, that cost is split among all tenants through the CAM charge. But replacing a faulty dishwasher inside a specific unit 302 would be the landlord's or that tenant's direct responsibility, not a CAM charge.
Exactly. CAM is about the shared infrastructure, and it's an integral part of the financial structure that often surprises new commercial lessees, as it can be a highly variable, significant additional cost beyond the base rent.
Let's circle back to the security deposit. We mentioned it's held in escrow. What modern legal protections are in place to ensure the tenant doesn't simply lose it unjustly?
The deposit is the tenant's money, held in trust by the landlord until the end of the term, minus legitimate damage. But the regulations around deposits are incredibly strict in many states, reflecting modern consumer protection.
Give us the specifics. What should the listener look for?
Some states require the landlord to provide the tenant with the bank name and account number where the security deposit is being held. And in high-cost areas, some laws even require the payment of annual interest to the tenant on that escrowed amount. Furthermore, many protective rules require the landlord to submit a list of pre-existing damage to the property upon move-in. If the landlord fails to document existing damage at the start of the tenancy, they may forfeit the right to use the deposit to claim damages at move-out. This is a crucial protection, proving the damage was caused by the current tenant, not a previous one.
That shifts the burden of proof to the landlord, which is significant. Now let's move to the tenant's own insurance protection. Renter's insurance. If the building has insurance, why do I still need my own policy?
You need it because the apartment complex's blanket policy only covers the structure itself and the landlord's liability for the structure. It does not cover your personal belongings, nor does it cover your liability to others resulting from your negligence. A renter needs a specialized policy, known in the industry as an HO4 policy, or renter's coverage.
And what does that HO4 actually cover for the lessee?
This policy covers two main areas. First, the apartment's contents, everything you own, like furniture, clothing, and electronics, often covering them at replacement cost. Second, and critically important, it covers personal liability. For example, if a guest slips on your rug and breaks a leg, or if your bathtub overflows and causes water damage to the unit below you.
And the coverage is typically based on named perils.
Correct. HO4 provides named peril coverage, meaning the policy specifically lists the events you are insured against. Common examples are fire and lightning, smoke damage, theft and vandalism, accidental water discharge from plumbing, and windstorm or hail. It's important to note what is often excluded unless purchased separately, such as damage from floods or earthquakes.
Let's pivot away from real estate and back to tangible personal property, specifically car leases. The same lessor-lessee principle applies. What are the specific provisions we see in a car rental agreement that mirror the protective clauses in a property lease?
The car lease is a textbook example of a highly restrictive use contract designed to protect a depreciating asset. You will see strict clauses dictating where you cannot drive the vehicle, a prohibition on driving off-road, perhaps a geographical limitation like you must stay within the continental U.S., or a prohibition on towing a trailer without specific permission. In some jurisdictions, the contract even includes GPS monitoring clauses.
And what about the people allowed to use the asset?
Strict requirements for documentation are standard. A valid driver's license, and only those drivers explicitly listed on the contract may be authorized to operate the vehicle. Financially, the renter assumes responsibility for all third-party costs accrued during the rental period, including tolls, parking tickets, or traffic infractions. You are responsible for the asset while it is in your exclusive possession.
Finally, let's briefly acknowledge the massive scale of equipment leasing as a financing tool for businesses.
This is a huge, specialized field. Leasing allows companies to acquire expensive industrial, medical, IT, construction, and manufacturing machinery without the massive upfront capital investment, often structured to keep the asset off the balance sheet for accounting purposes. This type of sophisticated financing is typically provided by major banks, captive finance companies owned by manufacturers, and independent finance firms, demonstrating the lease is a vital component of global business infrastructure, not just a way to rent an apartment.
We now enter the final layer of complexity, the sublease. This is when the original tenant decides to rent the space or asset to a third party. This sounds simple, but legally, it creates an interlocking relationship that can be incredibly risky for the original tenant.
When you sublease or sublet, the original lessee takes on a dual role and the liability chain becomes layered. The original lessee becomes the sublessor and the new party becomes the sublessee or subtenant. The sublessor is now managing two contracts simultaneously, the original lease with the owner and the new sublease with the sublessee.
This sounds convenient, but it carries a massive hidden legal risk for the sublessor. This is the crucial liability trap, right?
Absolutely. The sublessor must understand this core legal point. The sublessor remains fully and unconditionally liable to the original lessor for every single initial lease term. This means every remaining rent payment, every operating expense, and adherence to all original clauses.
So let's say I sublease my $4,000 commercial space to someone else for the last year of my lease. If my subtenant stops paying rent or even damages the property, the original landlord comes after me for the money and the repairs, not the subtenant. I still have to pay the full amount, even if I have to sue the subtenant separately.
Correct. The original lessor maintains privity of contract with the original lessee. The subtenant's legal relationship is primarily with the sublessor. You, the sublessor, are responsible for covering the shortfall, repairing the damage, and then attempting to recoup that money from your sublessee, a potentially long and expensive process.
Let's discuss the financial implications, which depend heavily on the prevailing market conditions.
If the market price for the property has increased, an upmarket, the sublessor might secure a higher rent from the sublessee than they originally paid. They make a profit on the differential. However, many sophisticated commercial leases stipulate that any financial overages or profits in rent must be shared with the original landlord.
That makes perfect sense. The landlord wants a slice of the increased market value of their asset since they own the underlying asset. Is there a common split?
It varies, but it might be a 50-50 split of the overage, or sometimes even higher in the landlord's favor. The tenant needs to check their original lease for a clause often titled sharing of excess rent.
Conversely, what if the market has softened a down market?
If the market price is decreased, the original lessee must cover the entire difference owed to the landlord. If the original rent was $5,000, but the best the sublessee can pay is $3,500, the sublessor is on the hook for the remaining $1,500 every single month. Subleasing is a risk management exercise, and the risk lies squarely with the original tenant.
Finally, we must mention that subletting isn't just a simple contractual issue. In regulated environments, it can be outright illegal and carry severe penalties.
Absolutely. In residential real estate, particularly where rent control or stabilization is in effect, it may be illegal to charge the subtenant more than the original controlled rent amount. This prevents profiteering off subsidized housing. More severely, the subletting of social housing or public housing is often illegal and described as a serious category of housing fraud in jurisdictions like the UK and New York City.
And certain cooperative housing arrangements prohibit it entirely to protect the specific nature of the tenancy and ensure that the subsidized benefit goes to the intended resident.
Yes. For example, Mitchell-Lama cooperatives in New York, which are subsidized middle-income housing, prohibit subletting because residents must maintain the unit as their primary residence. If you are caught subletting, it's a direct violation of the rules that maintain the affordable housing benefit, and the consequences can include eviction and being barred from future participation. The lease, in these cases, protects the entire system, not just the landlord's interests.
Wow. We started with the simple act of signing a rental agreement, and we've ended up traversing the legal hybrid nature of the lease, centuries of property law, the nuances of the four tenancy types, the complexity of commercial financials like CAM, and the substantial liability inherent in a sublease.
We've established that a lease is truly a legal hybrid, a conveyance of possessory rights that gives you immediate exclusionary control over an asset. We mapped the four crucial states of time, from the definite fixed term to the dangerous tenancy at sufferance. And we highlighted that transparency isn't just a suggestion, it's a legal requirement that modern consumer law is actively enforcing.
The ultimate takeaway for you, our listener, is that knowing these legal distinctions is your ultimate protection. Understanding that you legally possess the property, rather than just renting a service, fundamentally changes your relationship with the owner and clarifies your rights against intrusion or illegal eviction. Remember, the triple damage is awarded for unlawful self-help eviction. That's your possessory right in action.
And that leads us to the final thought on the evolution of lease law. It began rooted in common law, which operated under the faulty assumption of equal bargaining power. We've seen necessary advancements, specific legal protections, mandated deposit rules, and rent stabilization ordinances implemented to correct that failure, especially when dealing with fundamental necessities like housing.
So, what does this all mean for the future of the lease?
The question remains, knowing the depth of the rules and the historical context, how much further do consumer protection laws need to go to truly balance the relationship between the owner of capital and the user of the asset? Even with all these advancements, the fine print still dictates much of the balance, especially in non-residential leases. The deep dive into your next lease should start long before you sign the document by checking whether those terms are transparent and whether they truly respect the powerful possessory rights you are about to acquire.